What is up, guys? It's your friend, the Lazy Life Guide. Thank you for joining me again today. I really appreciate your company. Today, let's resume our discussion on how the law can protect principals either by regulating or governing agents. So, in the previous two videos, we talked about three classes of strategies that the law can implement to protect principals. The first strategy involved constraining agents either by rules which occur before the agent acts or standards which occur after the agent acts. The second class of strategies includes regulating the terms of affiliation, in which case the entry of the agent is being regulated and the opportunities for the principal to exit are being regulated. The third class of strategies involves aligning the incentives between the principal and agent in the form of governance. This can be done either by removing incentives via the trusteeship strategy to ensure that the agent can execute his duties as a trustee well, or it can be by adding incentives at the end of the agent's actions to ensure that the agent gets rewarded if he were to further his principal's intentions and welfare. So those are the first three classes of strategies that can be used to protect principals. Let's now turn to the last two classes of strategies that can be used to protect principals as discussed by the textbook Anatomy of Corporate Law. The fourth class of strategy involves the right to appoint. What does the right to appoint mean? Well, as the name suggests, the right to appoint means that the principal has the right to either select the agent that he wants to act for him or to remove the agent that he does not want to act for him anymore. So selection is the process that occurs before the whole agency relationship is constituted. In fact, it is the very step that is used to kick off the whole procedure. One very good example of selection rights involves shareholders electing board of director members to sit on the board because the shareholders are the principals in that they are the ones who own the company. But because they do not necessarily have the time or expertise to do so, they select agents, in this case board directors, to sit on the board to help them govern the company as agents. That are selection rights. Removal rights are just the opposite. If, suppose, the agent is acting in a way that really does not benefit the principal anymore, then the principal reserves the right to remove defective agents or rogue agents from acting for the principal anymore. So the converse of electing board members to the board of directors would be the right to remove board members from the board of directors. So that is the fourth class of strategies. The last class of strategies involve decision rights. As the name implies, decision rights are really an extraordinary class of strategies in that they allow the principal to directly be involved with the whole process of decision making itself. Which is kind of strange if you think about it, because the whole point of agency is to outsource the work of making decisions from the principal to the agent, such that the agent is one that is making the decision. But in the last class of strategies, it seems that the decision that is being required of the agent is so important that the law decides to give the principal the right to directly step in and into the decision-making process itself. The rights to the decision-making process can be split up into, again, two portions, either initiation or veto. As the name implies, initiation rights give the principal the right to initiate decisions on the agent's behalf. So instead of waiting for the agent to come up with the decision-making process, the agent can kickstart this process and in fact offer to the agent a proposed action or even undertake the decision itself. But as I have mentioned at the beginning of this strategy, this class of strategies is so extraordinary in a sense that it really hasn't been seen anywhere in practice. This is because allowing the principal to act unilaterally by initiating decisions on the agency relationship's behalf really can't be justified given the whole concept of agency, because why would you appoint an agent if you yourself are going to initiate the decision? It just doesn't seem logical in a sense, and therefore in the textbook, you will find that there's really no example that is being provided. The second class of strategies, however, which is veto, is a bit more common in a sense. So veto allows the principal to veto decisions that were being made by the agent if it turns out that the decision was something that really shouldn't have been made in the first place. So you can really see how veto protects the principal in the sense that the agent first acts by making a decision on the principal's behalf, and then the principal reserves the right to later step in and say, I disagree, so I will exercise my veto right to veto it. A very closely related right to veto will be the right of ratification. So ratification is kind of like the opposite of veto, but it also operates after the agent has acted. So in a sense, the agent acts first, and then the principal must approve of the decision that was being made by the agent. If an example would be relevant here, it's kind of like a computer doing some actions, and then after that the computer asks you, do I confirm this particular action should be undertaken? And then you can either say yes, so in this case you will ratify the decision, or you can say no, in this case you will veto the decision that was being made. Again, however, because the very fact is that the principal had actually outsourced the decision-making process to the agent, it would be strange if you will allow the agent decision to be so easily vetoed by the principal. So in this case, you will see that in the textbook, you will find that there are very, very little examples of veto rights that are being given to principals. Perhaps the most outstanding example would be that in the case of very, very important decisions that are being undertaken by agents. For example, if let's say the agents, which maybe say are majority shareholders, or maybe say the board of directors acting on behalf of shareholders as a whole, decides to amend the company constitution. So for example, if the majority shareholders or the board of directors suddenly convene a meeting and say, I know that our company has been manufacturing computer chips for the past 50 years, and that is in our constitution, but now we will amend our constitution so that instead of manufacturing computer chips, we will now manufacture potato chips, and the decision shall be final. Then in this case, because there is such a fundamental change that is being made to the company constitution, then the principals, which in this case may be either the minority shareholders or maybe the class of shareholders as a whole, respectively, may have the right to veto this decision that is being made. You say, that's not right. Our founding constitution clearly states computer chips, and all of our equipment are being set up to manufacture computer chips. So if you were to change to potato chips, then it really doesn't make any sense in terms of an investment perspective. So that would be an example of a veto right that is being given. And there you have it. So those are the 5 strategies that the law uses to protect principals from the actions of agents that may be detrimental to the principal's interests. We can either regulate the conduct that the agent and principals are allowed to take in the agency relationship, either by constraining the agent by rules or standards, or by controlling how the agents and principals are allowed to enter and exit this relationship. Alternatively, instead of regulating the conduct of agents and principals, we can focus on governance strategies, which takes care of the entire ecosystem and atmosphere that surrounds the agency relationship. This can be done either by aligning the incentives between the agent and principal, by removing incentives that occur before the agency relationship is constituted, or giving a reward to the agent after the agent has done good by his principal. Alternatively, another way that we can establish proper governance between the agent and principal is via appointment rights, which allow the principal to select or to remove agents. And the final governance strategy, which takes care of the entire atmosphere in which the agent acts, is initiation rights or veto rights. So initiation allows the principal to say, I approve of this decision, let's go, or to say, I disapprove of this decision, stop. In both situations, it gives the principal a direct hand in how the final outcome is going to be. So that is the video. on the introduction to agency, and I thank you all for listening. I hope you found this useful, and I wish you all the best in your Law of Agency course. Do leave a comment if you have any questions, and I'll do my best to answer them. Alternatively, if you guys are keen on learning more about the Law of Agency, do drop me a private message, and I can see whether I can continue this series in the future. Till next time, my friends, I rest my case.